Okay, I think we'll get underway. Good afternoon, everybody. Welcome to beautiful Westminster Hall and to Maryland Law School. I'm Peter Danchin, Associate Dean for Research and Faculty here at the Law School. We're absolutely delighted to be hosting and co-sponsoring this legal forum this afternoon, convened by We the People Maryland and the League of Women Voters of Maryland on the topic of the Supreme Court crisis of legitimacy and path to reform. Before we begin, I'd especially like to thank Charlie Cooper for all his efforts in organizing and conceiving this legal forum at really a very opportune time, I think. And I would also like to thank our incredible events team here at the law school, particularly Jessica Williams and Heather McElveen, for all the behind-the-scenes organizing that goes into an event like this. Well, I think it's fair to say that recent events have clearly deepened what our long-term or long-simmering controversies regarding the legitimacy of the U.S. Supreme Court. It seemed that last week, virtually every day, there were new revelations that were coming in the press regarding the activities of lack of disclosure by certain justices and regarding the workings of the court itself. And just yesterday, the Senate Judiciary Committee held a hearing on Supreme Court ethics reform that looked at the current lack of binding ethical standards that pertain to Supreme Court justices. So this really is the question of our day, and these are some of the big themes for our forum and conversation this afternoon. The program that will unfold now is in two panels. The first panel is going to look at some of the history of constitutional doctrines and controversies that really go to the heart of our conception of American constitutional democracy, as well as looking at some of the significant cases and practices of the Supreme Court that have a particular impact on voting rights. And as part of the panel, of course, there will be time for dialogue and questions from the audience, and we're looking forward to that exchange. Then the second panel is going to look at some of the historical background and politics that surround the current controversies involving the court, as well, of course, at looking at some of the current proposals and pathways to reform that may be becoming more of a reality today. So we're really, again, terrifically excited to be hosting this program. And without further ado, I'd like to introduce Nancy Sareng, the president of the League of Women Voters of Maryland, who's going to introduce our panelists on the first panel. Thank you very much.
Well, thank you, Dean Danchin, for that wonderful welcome. I get the pleasure of introducing our fabulous panelists, so I'm going to just dive right into that. Mark Graber is one of only 6 Regents professors in the history of University of Maryland. He's recognized as one of the leading scholars in the country on constitutional law and politics. He's the author of A New Introduction to American Constitutionalism and Dred Scott and the Problem of Constitutional Evil, and numerous other publications that would take up all our time if I told you about them. The League has been proud to collaborate with Professor Graber and the University of Maryland Francis Carey School of Law for 16 years on our at our Constitution Day events in September. And we plan to do it again for our 17th year. It's also my pleasure to introduce Leslie Prohl. She's Senior Director of the Voting Rights Program for the Leadership Conference on Civil and Human Rights. Their mission is to protect civil and human rights of all persons in the United States. The Leadership Conference is one of the nation's oldest, largest, and most diverse civil and human rights coalitions. And I'm proud to say the League of Women Voters is a member of that distinguished organization. And John Sherman is the litigation director of the Fair Election Center, where he oversees and has litigated numerous cases to defend the right to vote around the country. Prior to joining the Fair Election Center in 2013, John clerked in Phoenix, Arizona for Judge Barry Silverman on the U.S. Court of Appeals for the Ninth Circuit. He's collaborated with the League of Women Voters on various issues, and most recently is filing our brief on Moore v. Harper, which you will hear more about this afternoon. So we'll begin with our panelists. Thank you.
First, again, on behalf of the law school, I'd like to welcome you to what is by far and away the coldest room in the law school and the one with the worst acoustics. If you get too cold, the good news is every other room in the law school is warmer. If you can make neither head nor tails of what I'm saying, imagine the best talk you've ever heard and just replay that in your mind and congratulate me afterwards. What I'd like to do is simply outline the structure of voting in the United States. We begin with a constitution that does not explicitly give anyone the right to vote. The only right to vote you have in 1787 is if you can vote for the most numerous house of your state legislature, you have a right to vote in federal elections. Now, the Warren Court said while there was no explicit right to vote, the right to vote was part of equal protection. So if the government gave the right to some adults, they had to give it to others unless they had a compelling reason. So if you take my con law exam for civil liberties, there's always a question where they take a governor's office and make it appointed. You have no right to vote for governor. But if they say people with college educations can vote for governor, they have to allow all adults or give a compelling reason why they're excluding people. And so far, the only reason that has passed muster is you have a felony conviction. You not only have a right to vote, you have a right to an equal vote. My vote must be the same as their vote. So one way of thinking about it is if, imagine we voted on a piece of paper and we accidentally run into each other and we drop our pieces of paper and I pick up by accident John's and John picks up mine. Doesn't matter. Our votes are equal. And for the most part, the Supreme Court has said, when you do congressional districts, and to a lesser extent state districts, they must be of approximately equal population. Now, it's important to understand equal population does not mean gerrymanders. Gerrymanders, the feature of gerrymanders is equal population, but what you do is you pack all of your opponents in one district. So the good news for your opponents is they win that district, 100-1. Then you allocate every other seat such that the district is pretty safe. You win it 60-40. The result is, as in places like North Carolina and Wisconsin, you can control the state legislature. You can control the congressional delegation even though you only get half the vote or even less. The Supreme Court has said we don't deal with that problem. We can't figure out what fair election districts are. If it meets one person, one vote, if there is no race discrimination, that's a question we leave to Congress and the states. Regulating elections. Unlike the right to vote, which you can simply say is open to everybody, you have to regulate elections. You have to decide, where are we going to put the voting booth? How long are they going to be open? They can't be open 24 hours a day, 365 days a week. There's got to be an election day. And so the Supreme Court has said basically a balancing test. Now, during the early days of the balancing test, a lot of state legislation failed. Nowadays, the Supreme Court is inclined to draw the balance on the side of the state. So, for example, Indiana initiated the require a photo ID. And the legislature was pretty honest. Why do we require a photo ID? Because we think more Republicans have them than Democrats. We think more affluent people have them than non-affluent people. We think more white people have them than African Americans. And the Supreme Court said, well, you know, it's reasonable to want ID. There might be voting fraud. Okay, there's never been in-person voting fraud of this sort in Indiana, but it might happen on star date 2932, and we don't want Captain Kirk to get in trouble, and so we're deciding you can do this pending real proof in action. It has discriminatory effects. Some state judges have found in action it has discriminatory effects, but so far this court has not found that. There is also campaign finance. Now, one of the curious things, campaign finance is judged under free speech rather than the right to vote. Now, one of the curious things about this is that not all, not even most, campaign finance actually goes to speech. A lot of campaign finance goes to donuts, right? For those who've worked on a campaign, one of the things you have to do is you have to feed your campaign workers. Now, I like donuts as much as the next person, but I have to confess that I think now I'm speaking, when I'm having donuts, I don't think it's a First Amendment right. The Supreme Court said, no, I'm wrong. If I'm working on a campaign and they buy me donuts, the money that goes to buy me donuts is free speech. And so the rules have been that you can only regulate contributions of the size that are likely to corrupt in the sense of quid pro quo corruption. That is, if I say, I'll give you $30 on the condition you vote for a bill I like, that's not a problem. So that is, we can regulate that. But if I say, I give you $30 and in return, every week I get to come to your office and give you advice, well, that's not corruption. That's simply my giving speech. So the Supreme Court has increasingly said that almost all campaign finance is protected speech, even to the point of what we once thought was clearly something government could regulate: disclosure. Okay, we can't regulate what you give. At least the candidate has to say, I'm taking money from big oil. I'm taking money from a pro-life group. I'm taking money from a pro-choice group. We've recently seen inroads in that. And the inroads come from a case I would suspect most of us would agree with. Namely, southern states wanted everyone to reveal who was in the NAACP. Because, of course, in the 1950s, if you revealed you were in the NAACP, you got fired. They have now said, well, basically, major industries might have the same worry. You know, my God, if we knew Exxon was contributing to this candidate, we could do the same things to Exxon that were being done to African Americans in the 1950s. And so the court has been taking a chopping block to disclosure regulations. And so this is the state of the law. I haven't gone through the Voting Rights Act because I'd like time for the other speakers, frankly, and they are far more expert on the Voting Rights Act than I have. Happy to answer any questions as they arise. Thank you.
Can you guys hear me? I hope you don't mind. I just want to make an observation. You had the law professor go up to the podium, and the two advocates would rather sit here at the table. So I hope that's okay. Thank you so much for inviting me here today. Special shout out to my old friend, Dean Renee Hutchins of the law school. I'm so honored to be invited here and to see you. I was going to come looking for you after this anyway, so I'm glad you came. Huge thanks to the League of Women Voters for sponsoring this. I have to tell you, I get invitations to speak, and when I saw that it was you all, I immediately said yes. You are just a true partner to the Leadership Conference. We work side by side. I'm about to leave this panel and get on a meeting, and you all will be on it. I was just in Selma at the beginning of March to commemorate the 58th anniversary of Bloody Sunday, and was there with your president and the chair of your board, whom I met. And the case, one of the cases that's pending before the Supreme Court right now, Moore versus Harper, that I'm going to leave your able counsel to talk about. I have to tell you, I attended that oral argument and sat alongside one of the league's lawyers. And so we are definitely in the trenches together, and I'm very honored to talk to you today. So, you know, I wanted to kind of come at this with respect to making sure you know about the devastating blows that the Supreme Court has given to democracy in these last 10 years, and it shows no sign of slowing down. And I want to step back and give a little history lesson on the Voting Rights Act so that you can fully appreciate the harm that the court has caused and is continuing to cause. And I want to talk about this provision in the Voting Rights Act that was created in 1965. This is something that the 1965 Congress thought up, and that was that jurisdictions, states, localities with histories of discrimination in voting had to basically seek pre-approval of any changes they were going to make to voting before they implemented those. And so it was something that it's not new. It's, you know, Congress in 1965 thought that this was the only way to make sure that voting discrimination would not occur. And one of the impetuses is that it's really hard to unring the bell once an election has happened and the discrimination has occurred. Unlike in other areas of civil rights, if you think about it. In employment discrimination, you can sue, you can get the promotion, you can get the back pay. Housing discrimination, you can be given the apartment or the house that was infected by discrimination in terms of the transaction, but it's really hard to undo an election. And so the idea was to get out in front of the discrimination, to have the Department of Justice or a three-judge court look at the voting change, see if it's going to disproportionately impact voters of color, and then approve it or object to it. And so we've had that framework for decades. And because it was such an extraordinary measure, Congress in 1965 decided that that particular provision, which we call Section 5 of the Voting Rights Act, the preclearance provision, should be reauthorized by Congress every so often. And so it has been reauthorized 4 different times. The last time it was reauthorized, I worked on that, as did a lot of other civil rights organizations. And it was in 2006, and Congress reauthorized that. The vote in the Senate was 98-0. In the House, it was very, very lopsided as well. And I went to the Rose Garden ceremony with George W. Bush, who signed that act. So that's how recently the Voting Rights Act has been supported very strongly in a bipartisan way. And what happened after that reauthorization is, and we knew it was coming, we knew that there was going to be a constitutional challenge to that. And there had been after every reauthorization before that. So it's not like this was a new type of challenge. The problem is that the Supreme Court in every other instance had pushed it back and had not declared that it was unconstitutional, but had said it's absolutely constitutional and you can continue to use it. The problem was this court, in just an incredibly devastating opinion by Chief Justice John Roberts in a case called Shelby County versus Holder that's almost 10 years old. We're going to be marking the anniversary on June 25th of a complete decade of the Shelby County case. What the court did is they ignored just reams of congressional evidence and record that was built up to show that we still needed this pre-clearance provision, and basically said, our country has changed and this is just too onerous of a provision to impose on states that have seen the light. There's not as much discrimination. People are turning out to vote. All these reasons that they identified for the decision, none of them were valid. And what happened at the moment of that decision, and I wanted to share that I was actually in the court when that decision came down. I was with the NAACP Legal Defense Fund, where I worked for a long time and worked alongside Sherilyn Ifill, who was a longtime law professor at this school, and she was director counsel at the time. And I was in the court, and I was sitting between two veteran voting rights lawyers. One of them had litigated voting rights cases in the 60s in Mississippi, and another one, almost as that long. And we were sitting there and, saying it's not going to happen. They can't do it. They just can't declare this unconstitutional. It's not going to happen. It's not going to happen. And then the court came in, and as is customary, the justice who has authored the majority opinion starts reading from it. And we knew we were doomed when it was Chief Justice Roberts who opened his mouth and began reading the decision, which gutted the heart of the Voting Rights Act, as John Lewis said. And so I still remember the gut punch when I understood what was happening. And the states that were supposed to be still under preclearance but were suddenly released from preclearance knew exactly what they had been now licensed to do, and the ink was not dry on the opinion before the state of Texas enacted a horrible photo ID law that had been deemed to be discriminatory by an earlier opinion of the Department of Justice. North Carolina did the same thing. Alabama did the same thing. The floodgates opened because no longer were they required to get this pre-clearance, pre-check to see whether the acts were discriminatory. And the really sad thing, and we're going to be writing about this and talking about this as we move up to this anniversary date, is it hasn't stopped. These states and these localities, it's not just the states, it's the localities, went into overdrive immediately to start enacting these voter restrictions, and they haven't let up. And they've actually kept the same ones, the voter ID, rolling back early voting, trying to get citizenship, requirements before you register and before you vote. There's a litany of things that were going on right as Shelby came down, but they've also morphed into kind of other forms of discrimination now. Voter purges, we have election sabotage, we have states like Georgia who are stripping the power of local election officials to do the right thing. So it's the state election board that kind of controls more the mechanics of the election. So we're in a very dire situation. And we have been trying to address this decision to restore and strengthen the Voting Rights Act since the case first came down through the John Lewis Voting Rights Bill, John Lewis Voting Rights Advancement Act, which the League has been a strong supporter of. I've been working on this now for a decade, trying to get this through Congress. I hope you all know that we got very close in the last Congress, but we're not able to get over the finish line because of the change it would have required to the filibuster rule, which Senators Manchin and Sinema refused to go along with. And so we lost that opportunity. We're, unlikely to get it passed in this Congress with a divided House and Senate. But we're, are entering our second decade of trying to restore this, and the civil rights groups are going nowhere, and the League is going nowhere, and we're going to continue to keep making the case to get this bill passed and to repair the damage that has done. Now, that is not the only thing, however, that the court has done, and you're going to hear what's potentially on the chopping block in another case. But I also wanted to tell you about the second voting case that's pending this year, and that is a redistricting case, again out of Alabama, where it was the plaintiffs down in Alabama challenged the failure of the Alabama legislature to create a second majority Black congressional district. They have 7 congressional districts in Alabama, and since the early 1990s, only one of them has been majority Black. That is the district that's represented. It covers Selma, and Representative Terry Sewell, who's actually the original co-sponsor of the John Lewis bill. That's her district. The Alabama proportion of Black population in Alabama now is 27%. Every redistricting principle that has been followed over the last decades indicates that Alabama is long due, frankly, for a second majority Black district. And the Alabama legislature refused to adopt a map that had 2 majority Black districts. The plaintiffs sued. There was a 3-judge court that heard the case initially, and 2 of the 3 judges were Trump appointees, and the 3rd judge was, I think, a George Bush appointee. All 3 judges said that that was a straight-up violation of Section 2 of the Voting Rights Act, that Alabama was entitled to a second Black majority congressional district, and the failure to give them one was a dilution of Black political power. And Alabama then appealed that case to the Supreme Court. That is pending before the court right now. It was one of Justice Ketanji Brown Jackson's first arguments. She was very passionate about it because Alabama was actually arguing there should be no role for consideration of race at all in redistricting, and she really pushed back on that. We remain hopeful that the court is going to do the right thing on this. We are also realists in thinking that this court, with this record on voting already, is likely to take a swipe at Section 2. Which will be, in addition to what they've already done to Section 5. And there's another case that happened in between called Bronovich versus DNC that undermined another part of Section 2, which is kind of the meat and potatoes litigation provision of the Voting Rights Act that came out in 2021 and undermined the ability of voters of color to bring vote denial cases. And it's very grim. I'm glad you're here and listening to this. We need everybody in every state to know about this and to communicate to your representatives just how badly we need this. I'm going to leave you with a comment that Justice Kagan made during this case that was just argued this year, and it's called Merrill versus Milligan. And she said, basically, I don't know what's going on, or maybe I do, but you in Shelby County, you said, meaning her colleagues, you said that the guts of the Voting Rights Act is really Section 2. Section 5 is just this, other provision that was really not that important. You said that in Shelby County. In Bronovich versus DNC, which was a Section 2 case, you said, vote denial cases are not that common. We're really talking about vote dilution cases with Section 2. Now, in Merrill versus Milligan, we've got a vote dilution case. And what are you going to do here? Because, if you continue the assault, what's left? And that is just a horrible thing to fathom. And, I'm hoping that, people mark this 10-year anniversary of Shelby. We're going to be, preparing with the league some things to lift it up and use it as an education moment. But I mean, we've got this decade of the assaults on Voting Rights Act, and you've got these two cases, Shelby County from Alabama, Merrill versus Milligan from Alabama, as the bookends to that. And so, is the court going to do what we expect it to do, unfortunately, or is it going to, surprise us all and uphold, a very important provision of the Voting Rights Act? We'll know in, within a couple months. But it's, incredibly disappointing and frustrating, and, so glad that you came out to listen to this, because we need every one of you in this fight. Thank you.
I want to thank the League for having me and inviting me to speak here. It's always an honor to be with the League. We've represented the League of Women Voters in Wisconsin, North Carolina, Louisiana, and in other states I'm probably forgetting, and most recently before the U.S. Supreme Court as an amicus in Moore v. Harper. I first, want to touch on some of the other cases that have been decided over the last 15 years by the U.S. Supreme Court on the merits, and then get into talking about the Supreme Court's shadow docket, which I think is less well known publicly and is extremely significant, right? It's not every day that the Supreme Court is actually reaching the merits and ruling on the merits of a voting rights or election law case. They come up, but much more frequently they're deciding cases on their emergency docket, and that's more harmful in many ways. Well, not more harmful, it's just that's where most of these decisions are being decided. Many of the election law cases that have been discussed have devastating consequences when they're decided on the merits, right? So one of these, Crawford versus Marion County Election Board, rejected a challenge to Indiana's strict photo ID law. This is back in 2008. Indiana and Georgia were sort of out front passing their strict photo ID laws for in-person voting. Democratic Party ran up to the U.S. Supreme Court, tried to strike down the law in its face. It was a pretty thin record, and in a 6-3 opinion actually authored by Justice Stevens at the time, they rejected that facial challenge to Indiana's voter ID law. And since then, of course, you've seen a mushrooming, it's spread like wildfire. Many states have voter ID laws. They vary. Not all are as strict as Georgia, or the most recently enacted law in Ohio. Some are more expansive, some include non-photo IDs, but this is a sort of devastating opinion that, you know, is sort of the origin of the expansion of voter ID all around the country. More recently, well, this is now actually same year as Shelby County was decided. Shelby County is, of course, probably the most devastating election law voting rights case at the court, I would say, in the last 15 years, for the reasons Leslie just described. Actually, that year there was probably the only decision I can think of from this period of time where voting rights advocates were able to win at the U.S. Supreme Court, and a decision, ironically enough, written by Justice Scalia, Arizona versus Intertribal Council of Arizona. That case protected the federal voter registration form, said essentially that the state of Arizona could not apply its documentary proof of citizenship requirement to the federal voter registration form that was created by the National Voter Registration Act, the Motor Voter Law of 1993. You at the League are probably well familiar with this decision, but that was that's pretty much the only case I can think of that voting rights plaintiffs have been able to win at the U.S. Supreme Court. More recently, APRI v. Usted out of Ohio, that makes its way up to the Supreme Court. This is another case under the National Voter Registration Act, and the court holds that what the Secretary of State of Ohio is doing in sending notices to voters who are not voting very frequently and missing elections, and then initiating purge and removal practices based on that non-response to a letter and their lack of voting, is not squarely prohibited by the National Voter Registration Act. That's another significant loss at the U.S. Supreme Court, and a very reasonable people could defer, I think, on the language in the NVRA here. That may not be a popular take on this particular decision, but it is a bad ruling in its outcome, and it does protect a number of the other states that are removing voters based on their non-voting in the past. Which brings me to Moore v. Harper, which is more recent and is pending before the U.S. Supreme Court right now. I'm sure everyone saw the news from Friday out of the Supreme Court of North Carolina. Supreme Court of North Carolina previously had struck down North Carolina's congressional map as a partisan gerrymander under the North Carolina Constitution. That goes up to the U.S. Supreme Court on a different theory. The different theory is that the state court, the state Supreme Court, in striking down a state law on state constitutional grounds, is violating the U.S. Constitution because this concerns congressional elections. And so the premise here is the extremist and heretofore fringe theory, the independent state legislature theory, which is that when state statutes, state laws govern and regulate federal elections, they are immune from state constitutional requirements. My view of the substance here is that this is a fantasy. There is no such thing as an independent state legislature. They are reading a particular part of the Constitution, though, to mean that when state legislatures act to regulate federal elections, they are immune from state constitutional review entirely. This is crazy. Why would state legislatures have more power with respect to federal elections than they do even with regulating their own state and local elections? We filed an amicus brief on behalf of the League with respect to this particular issue, right? Because the imbalance here is the state, this Moore v. Harper and this independent state legislature theory that's before the court has nothing to say about the regulation of state and local elections. So if the independent state legislature theory were adopted by the court, it would only have an impact on state statutes that regulate presidential and congressional elections, right? So if a state Supreme Court struck down a voter ID law They could only do that with respect to state and local elections. The opinion would be valid as to that, and there would be no voter ID law for state and local elections, but there would be a voter ID law in place for federal elections. So it would basically cause this bifurcation or split in election rules and voting rules. And you could think of the chaos this would cause around the country, whether it's a rule about eligibility, felon disenfranchisement, a rule about voter registration, say same-day voter registration, or a rule about the mechanics of how you cast an absentee ballot or vote in person. All of these rules would be split, and they would alternate. As the league well knows, there's always an election. Many of these elections don't have a federal election on the ballot. So if you have an election mid-year that only has state and local races on the ballot, some voting rules would come on, and then when an election would come with federal elections on the ballot, those rules would be switched off, or they would alternate or split or be split, enforced in a split way during that election. 69 amici briefs were filed in this case. It looks like it might all be for naught. There's a difference of opinion on how this might shake out. Some people at the court are arguing that the court should rule on the merits of the case, notwithstanding the Supreme Court of North Carolina reversing the prior decision. So what more recently happened, I should backtrack. On Friday of last week, the newly constituted Supreme Court of North Carolina, that now has a balance of power favoring the Republicans, ruled 5-2 in the rehearing of the underlying case here, and found that there's no jurisdiction, and therefore there's no gerrymander whatsoever, vacated the prior ruling, and now there is at least an argument that what's before the U.S. Supreme Court is moot because the North Carolina legislature has everything they wanted, even though they technically need to redraw their maps, but there is no finding that their congressional maps were an unconstitutional gerrymander. So we still don't have, as of today, we still don't have an order from the U.S. Supreme Court. I thought there might be by the time we had this panel, but we're all waiting. It could happen while we're sitting here, but there will be at some point a ruling from the U.S. Supreme Court. I'm betting that they will dismiss the case, either as moot or perhaps improvidently granted. And that's unfortunate in one respect, right? Because it would have been a good opportunity to kill this fantasy theory once and for all. And now there's at least a chance that it'll be decided next year in the course of the run-up to a presidential election, which is not ideal. It would be much better for the country if it had been disposed of this year, and I think it looks less likely that'll happen. But when they ultimately get the ISLT squarely before them again, we'll be there to represent the league once again and file a similar amicus brief arguing that they should not open this Pandora's box. I did want to shift, though, because not with respect to Moore, but with some of these other voting rights cases, and not with respect to Shelby County, that case as well. Shelby County is just completely beyond the pale. Some of these voting rights cases that reach the court, people can defer on them, and many people do. Many lawyers defer on them, and many people out there do defer on the outcome. The title of the talk today, though, Supreme Court Crisis of Legitimacy and the Path to Reform, I think to talk about the court's declining legitimacy, it's not just the outcome of the rulings in these particular cases, because reasonable people can defer on some of this. People defer, for instance, on whether the Constitution protects the right of same-sex couples to marry. We may have strong feelings about that, and the outcome is people are very passionate about the outcome, but the court's legitimacy shouldn't be called into question because it ruled that same-sex couples do have a constitutional right to marry. The court's legitimacy shouldn't be called into question because they had a particular reading of the National Voter Registration Act. But many of these cases in the election law space are not actually being decided on the merits. They're being decided on the quote-unquote shadow docket. And I realize not everyone in the audience here today is a trained lawyer, so just really quickly, the 30-second procedural history on how voting rights cases proceed. State legislature passes a new voting restriction. We find plaintiffs, we sue, we try to strike down that law, try to get the court to issue a permanent injunction, what's known as a permanent injunction. Striking down that law is unconstitutional or violating federal law. Sometimes you can get a preliminary injunction prior to getting that permanent injunction. The state defendants' lawyers, what they do is they appeal, and when they appeal, they run up to the circuit court and try to get that injunction stayed. A stay is sort of a suspension of the injunction. And then sometimes these cases proceed very quickly up to the US Supreme Court, and then on their emergency docket, people are filing emergency applications to either stay a lower court injunction that hasn't been stayed by the circuit court, or filing an emergency application to vacate a stay, to lift that stay, and reinstate the injunction. That's usually the posture I'm in. Give me back my injunction that the circuit court took away. So all of this is happening in a very fast briefing schedule and gets up to the US Supreme Court, and there are these rulings that come down, orders, very terse, usually with very few citations, if any. Sometimes there's a much lengthier concurrence or dissent, and many of these cases are being decided not based on the merits, not based on whether these voters are entitled to have their voting rights protected in this particular case, but simply based on whether the injunction was issued too close to the election. And the origin of this is a 2006 decision known as Purcell v. Gonzalez. You may have heard of what's been, I think, misnamed the quote-unquote Purcell principle. The basic idea that the Supreme Court comes up with in this case is that election laws the rules governing elections shouldn't be changed too close to an election. And the reasons they articulate in 2006 are the Supreme Court says it's worried about voter confusion and worried that voter confusion might lead to diminished turnout. And then later on in a 2020 case, they say, specifically Justice Kavanaugh says, he's also worried about election administrator confusion and the burden on election administrators. When this is decided back in 2006, no one knows that a new principle has been announced, and it doesn't really get going until 2014, when you start to see a number of these orders coming out, almost all of which are staying lower court injunctions that have been won by voting rights plaintiffs, and not based on some reading of the merits of the case, but simply because they were, quote, issued too close to the election. What too close to the election means is entirely unclear. And the way this is played out in practice is, I don't need to tell members of the league, you know this, there is always an election, always. I mean, there's a major general election every 2 years, but there's always an upcoming primary, there's always an upcoming special election, and the way this is played out in practice over the last, now going back to 2014 when this has really got going, is that there's just, gosh darn it, there's just no good time on the calendar for there to be a voting rights injunction. There's no good time to change election laws, even when voters' constitutional rights are being violated. So it's widely called the shadow docket, I think, for a reason, right? These cases are thinly reasoned. It's sort of semi-secret reasoning, and we also have to interpret what's happening based on sort of the shadow cast by the words, because everything is implicit in these emergency applications. Sort of shifting forward to 2018, 2020, now the liberal justices on the court start to use Purcell to their advantage and start citing it in dissent, saying, well, there was an injunction in place for a year, say barring the poll tax that returning citizens have to pay in Florida, or there was an injunction in place in North Dakota for the primary election for the better part of this whole year, expanding the number of acceptable voter IDs that can be used. And then the circuit court stepped in late in the game and stayed that injunction. So why shouldn't Purcell bar what the state circuit court is doing. The Supreme Court majority has not applied Purcell evenly and has said Purcell poses no problem when the circuit court steps in and stays that pro-voter injunction late and overturning the status quo that was helping out voters. We saw the same kind of activity during the pandemic, right? The pandemic erupts March 2020, and there is just a race, to scramble amongst voting rights advocates around the country to bring cases to reconcile the conflict between what the pandemic conditions were causing on the ground for voters with in-person voting and the restrictions that many states had imposed, right? Think of witnessing requirements all around the country. In South Carolina, you had to get your absentee ballot witnessed. I brought a case like this in Wisconsin. In South Carolina, they're requiring you to go interact with people in the height of the pandemic before vaccination. So many people tried to get these laws enjoined. The South Carolina witnessing requirement is enjoined. It makes its way up to the Supreme Court. That injunction is stayed on the premise that of Purcell, that it came too close to the election. Same thing in a case out of Wisconsin that I was involved with. We were able to secure alternative absentee ballot delivery methods, and others in that consolidated litigation got an extension of the deadline to return an absentee ballot. The Supreme Court swatted all of it, citing Purcell, too close to the election. In the Alabama redistricting challenge that Leslie was speaking about just a couple minutes ago, Merrill v. Milligan, Purcell was applied to block the new maps from going into effect, even though that was a permanent injunction, even though it had been through trial and there was a permanent injunction in place striking down Alabama's congressional map. You will be shocked to hear that Purcell was not applied in an even-handed way in a Wisconsin redistricting challenge. When the Supreme Court of Wisconsin had ruled in favor of minority voters in Wisconsin and ordered a map that was more favorable and more in keeping with the Voting Rights Act, the Supreme Court, U.S. Supreme Court, had no problem stepping in very close to the election and ordering new maps be drawn. So this principle has not been applied consistently. It's not really a principle because it's not applied in a uniform way. I'm probably going on way too long, but I'll just summarize a few points in conclusion. What are the consequences of this quote-unquote principle being applied on the shadow docket, being applied in a non-uniform way, in an arbitrary way, and having these rulings come out that are very thinly reasoned orders? You might be saying, like, why would you want the U.S. Supreme Court to be writing more about voting rights? But I think they should be. Right? I think if we're going to lose at the U.S. Supreme Court, they should tell us why. There should be a fulsome, reasoned opinion on the merits telling us why they're rejecting our constitutional claims. I think the voters and the voting rights organizations who are behind these cases deserve to know. And that's the way the law is shaped. There's no way to run a democracy and no way to run a judiciary to have opaque, cryptic, one half a page decisions swatting voting rights cases, and then that's the end of the game, and we never get to learn what was the actual basis of the reasoning. Not only does it deprive us of the knowledge of what the governing legal rules are for elections, it also deprives us, I think, of the sort of ancillary but important objective of forcing courts' hands, right? If the justices want to take us to a more lawless, authoritarian place, they should be signing their opinions. They should be telling us, they should be owning these decisions. So just in conclusion, Purcell and the sort of shadow docket that has emerged in the election law space is it's a stain on the court's legitimacy. Every decision that comes out, every order that comes out on the shadow docket that swats a voting rights injunction, a pro-voter injunction, without having a full review and a fully reasoned decision, I think is a stain on the court's legitimacy. There's pending legislation, part of the John Lewis bill, is to supersede the Purcell, is intended to supersede the Purcell principle. It's really called if you talk to any voting rights litigator, they will tell you they call it the Goldilocks principle, because defendants in their briefs simultaneously in a single brief will argue our decision is not yet ripe, our claim is not yet ripe for review, and it's also too late. So it's always too early for us to bring our voting rights claim, and it's always too late and too close to an election. So there's no good time on the calendar for us to win a voting rights case. It's an intolerable situation. I think this is extremely, this undermines the court's legitimacy greatly. I'll stop there. There's more I could say.
Thank you. One reason congressional gerrymandering is such a problem is that the House of Representatives is too small. But for congressional action, I think in the 1920s, the House would be much larger now than it is. And I wonder if you have any thoughts about the various proposals to enlarge the House of Representatives.
I'll give a very general answer. They're certainly out there, and in fact, people regularly call about those issues. I think that they're going to stay just that for a while. I think that there's always that we should at some point. So it's not front, of mind for the civil rights groups. And I will also say we're very busy doing this other work. And so I think, I don't know if we're ever going to get to a time where there's, resources, attention, the kind of willingness of Congress to address those very much larger structural issues. But it's definitely comes up every so often. But I just think as a very practical matter, it's going to be hard to catch fire.
Good afternoon. A very pleasure to meet you all. Thanks for your thoughts. I'm Beth Huffnagel. I'm the co-chair for League of Women Voters Maryland Redistricting Committee. And I had a specific question about Maryland. Mr. Sherman addressed the jurisdiction of the state courts over the federal congressional districting. In Maryland, this past one, we had a situation where the courts did rule that they were applying the same constitutional rights to the federal ones, and I'm happy to say that the legislature believed them, their authority, and made the changes. However, in the next step, that case was settled and did not actually go to a final judgment. I'm just wondering, in 2030, assuming the Supreme Court does not do this crazy legislators in charge of everything thing, will the state constitution apply to federal redistricting for congressional districts in 2030? Thank you.
Well, that remains to be seen with whether in 2030 ISLT is the law of the land. I'm hopeful that it won't be. For 233 years and counting, no one has discovered a principle of constitutional law, federal constitutional law, that means state legislatures can act independent of state constitutional requirements when they're regulating federal elections. And I think you heard during that oral argument over Moore v. Harper that the Supreme Court was struggling in real time to come up with a limiting principle. So they may look at what the Supreme Court of North Carolina has done last week and may sigh and take a sigh of relief and say, some of them, right? They don't have to actually wrestle with the hard question of what the limit is. Because if you adopt ISLT, it's not clear where it ends. Is a gubernatorial veto next? I mean, can a governor play no role in state lawmaking when it comes to federal elections? It's just not clear where it ends.
It's also, if I could add, a little puzzle. Namely, suppose you accept the independent state legislature theory. And I say, I'm the Maryland state legislature, or the three of us are. How do you know the three of us aren't the Maryland state legislature? There's only one way to know. You've got to look at the Maryland state constitution. Or we claim this was not passed, say, by the majority vote. How do you know the rules for how the Maryland state legislature could act? You have to look at the Maryland state constitution. In other words, independent state legislature makes no sense, because the only way you can understand that this is the Maryland state legislature is by looking at the same constitution the North Carolina legislature is now telling you you can't look at.
And
Justice Jackson made that point during the argument.
I was just going to say that she kept coming back to that. She was harping on that the entire argument. That's exactly right. One other thing I want you to know about this case is the unusual allies that are on our side, okay? It's pretty much, voting rights, community, and then conservative groups are usually on very opposite ends of these issues, right? In the Moore v. Harper case, his brief was joined by amicus briefs by the founder of the Federalist Society, Judge Michael Ludig of the Fourth Circuit, former Judge Ludig of the Fourth Circuit Court of Appeals, which is your federal circuit court, one of the most conservative judges on that court in the history of the court. He retired and now he's no longer a judge. He joined the plaintiff's brief on our side in the Moore case and has been a vocal supporter. He was in the court for the oral argument. He's now on Twitter saying he thinks that the court should still decide the question, which is our position. We want them to, announce. We want them to reject it now. But it is very unusual in a voting rights case to have that kind of support from conservative voices.
It also helped that the conservative amici brief, there were about 21 of them, and they all had a different version of ISLT. So they could not collectively, cohesively articulate what the independent state legislature theory was and its boundaries. They all had a different flavor of it.
Hi, my name is Arlene O'Gorick, and I'm a member of For the People Maryland. Chief Justice Roberts declined to testify at yesterday's Senate Judiciary hearing, asserting that the Senate is violating separation of powers with its ethics probe. All of the justices have signed off on the court's weak ethics plan. How do we know when separation of powers governs and when the Constitution requires branches to check and balance each other?
Who wants it?
Well, I'll say I watched some of that hearing, and I hope you all did. You can still watch it. There's a video on the Senate Judiciary Committee. I mean, I think Senator Durbin and some of the other senators really made some good points in their responsive letters to the Chief Justice. He wrote, I think, 2 different letters, and noting that justices had testified before Congress on, over 100 times, that they actually gave him an out if it was unseemly or some other reason, that the Chief Justice shouldn't testify, that another justice could come. And so he really, I think, did not end up making, any kind of, strong argument about why he didn't show. And I think his weak response to that really undermined their position, overall, because it was very formalistic and really didn't, rise to the moment of what they're being asked to do to begin with. So I don't know if other people have other views, but I think it was very cowardly and just shows you just how vast the problems are when they can't even show up to respond and defend the position of no ethics code.
It's funny that the justices didn't think, to go off what you said, it was inappropriate to request Congress for pay raises. Apparently that is not a violation of separation of powers. When they want things, then it's okay. And one sense is common sense. Does demanding disclosures of potential conflicts of interest enable the legislature to totally control the judiciary? Now, one of the, I think, stories, and I wrote the blog that I've written that got the most hits was basically saying Justice Breyer wrote a book that was an embarrassment. No other way to describe it. And we have justices writing books, giving lectures, going on tours, celebrity, the liberal justices, the conservative justices, and telling us that they do this because $285,000 a year is not enough to feed a family. And I think we need to tone down the celebrity court. That judges in our society, liberal conservatives, have become celebrities. We have contributed to their being celebrities. And I think we should stop. We might consider at this law school, we stop inviting judges. They say enough. Invite other people.
Next, please.
I kind of following up on that question, I think it was Preston that you said, we've heard some pretty scary judgments, but you said that the way that they judge should not reflect on their legitimacy. I mean, everybody's entitled to their opinion, and that's what we put them there for. And so I guess it kind of in a follow-up, when we become aware that judges are being influenced by money and other things, I guess I'd like to know, one of you said, join us in the fight. And I'm thinking, well, the Supreme Court is the Supreme Court. And what can we do? I guess I'm appalled that I don't trust the Supreme Court anymore. I don't think they have legitimacy. And yes, I'll be joining the fight, but what can we do when they are the Supreme Court?
It's a great question, and thank you for that. So I will say on the issues of voting rights, there is certainly a role for Congress to act. Congress can overturn the Shelby decision. If the court rules unfavorably in the Merrill versus Milligan case in a couple months, the Congress can restore Section 2 of the Voting Rights Act to its original interpretation, current interpretation before the court undermined it. So there's definitely a role for Congress, and that is what the John Lewis bill has been, that we've been trying to get Congress to pass and the president to sign for 10 years. So there's that, okay? With respect to the court itself, you probably know that there's now legislation to try to have them adopt an ethics code, right? There's that issue. There's now legislation that's getting more and more co-sponsors to expand the court to, I believe, add to, it would be 13 justices?
It
I think
varies.
it's, yeah, there's different proposals. That is growing as, you know, people are getting more and more alarmed. There's also,
Does the Congress have the power to do that?
oh, absolutely.
Oh, thank you.
Absolutely, yeah. And to impose, there's another proposal that some people find a little bit more palatable, and that's for term limits on the justices because they're, you know, for life. And so there's definitely, in my lifetime of kind of, you know, being a civil rights lawyer and kind of seeing where the court, it's never been a good court, really, you know, as far as my career, but I have never seen such a momentum around fixing it in very specific ways. And, you know, I think, frankly, some of the reproductive rights groups are, you know, after Dobbs, are, you know, joining that effort. There was a big announcement, you know, Senator Warren is at the forefront of some of those efforts, those reform efforts. There was a big announcement that I think Planned Parenthood is joining that effort to, you know, expand the court, reform the court. And so stay tuned because it's only gonna, I think, get stronger.
I'd like to follow up on that a little bit. So, with respect to the terms, the Constitution says something like they shall serve during good behavior. But the Brennan Center just put out a statement saying that they think that an 18-year limit could, where they would then be assigned to lower courts or to substitute on the Supreme Court upon recusal or illness or absence or whatever, could possibly be done by statute. So do you all have any comments on whether the terms can be done, you know, what can be done by statute and what requires a constitutional amendment, which is, as I've found out, trying to work to overturn Citizens United. Constitutional amendment's sort of difficult. We have to keep at it, but
Yeah.
Do you know who's going to decide that question? The Supreme Court.
And that's a serious thing.
Yeah.
Here, maybe as a bottom line, I'm going to suggest to people, namely, we're in a time of a constitutional revolution where the rules that governed us since about 1937 don't govern any longer. And if you like what the Republican Party is doing, you think all of this is justified. After all, it's 1.5 million unborn babies from your perspective. Not endorsing it, simply want to understand what's going on. Now, a crucial thing about a revolution is you can never go back to before. So the rule that you can't pack the court is a rule from 1937. It doesn't say that, okay, now if progressives get a firmer control of politics, there are things that are now open that were not open 40 years ago, because in some sense we are creating a new constitutional regime, whether we like it or not, and asserting, well, this is the way we did things in 1980, just doesn't hack it with Republicans, and it shouldn't hack it with others either anymore. I mean, it's always very frustrating, particularly for you teach con law, because one of the real advantages of teaching con law in normal times is my lectures from last year are pretty much, you know, good for this year. It's not true anymore.
Yeah, I do.
Okay.
I'm sorry, I have to step out. for a
Leslie has
meeting
another.
with the League of Women Voters, okay?
Yeah, that's blame them.
I just want to say that your answer
so
gave me
much.
hope. Thank you very much.
But we can continue with questions and answers.
Good to meet you. I've gotten so many emails over years from you.
Right into the mic, please.
This question is for Professor Prager mostly, but I'd like to hear what anyone has to say. Fictitious people, corporations are fictitious people. Is there any reason that Congress can't pass laws, any legal or constitutional reason, that Congress couldn't pass a law that says that a corporation doesn't have First Amendment rights?
Well, the short reason is the Supreme Court has said you can't do it. Now,
In what case?
Supreme Court has decided ever since a case called Santa Fe Railroad Santa Clara Railroad in 1887 that corporations are constitutional persons. Now, this is because the Supreme Court is committed to an anti-original understanding. Since I've just finished a book on the 14th Amendment, there is absolutely no reference to corporations as legal persons by the framers. And here, sometimes no means only a few. No, here, no means no, zero. Now, one might argue that persons who form corporations have rights. The difficulty is normally it's when the government gives you benefits. Government can insist you use those benefits for A and not B. So for example, if I get food stamps from the government, I can't sell my food stamps to you and then use the money to make speeches. The court has, for some reason, decided no, corporations may use their financial advantages gained with government law and transfer them to the market. Now, again, we're in a time of revolution. The way you beat a revolution is not by pointing out to the revolutionaries, I've got a law professor who says you're wrong. I got lots of law professors who say you're wrong. The way you beat a revolution is by out-mobilizing the revolutionaries. When progressives, or when progressive centrists, whatever, out-mobilize the mega crowd, corporation speech will be limited. If they do not out-mobilize the mega crowd, it won't be. Simple as that.
But there is no, I don't see any prohibition to Congress passing a law that says that a corporation is a fictitious person and therefore it has limited constitutional rights. Yes, there are cases saying that, Citizens United being the first one, the most prominent.
But if you're asking me, Congress can, and here the can-may distinction really matters. In one sense, Congress can pass any law it wants. Congress can pass a law saying all Americans must worship the Greek gods. The Supreme Court is likely to declare it unconstitutional, but Congress can pass that law. The question is, when Congress passes the law, will it stick? Will it matter? Not simply as a lot of state legislatures, when Roe v. Wade was good law, passed anti-abortion laws for the simple reason that their constituents said, wow, you're wonderful, and they didn't have to take any responsibility because the court killed it. So Congress can pass lots of laws. The more interesting question is, will they matter?
Yeah, this is a distinction I just wanted to underscore, right? Across a range of things we've been discussing, right? If the Supreme Court is ruling as a constitutional matter, then Congress can't supersede, right? But if they're ruling on just an interpretation of the National Voter Registration Act, and they say the NVRA doesn't prohibit X, Congress can enact a law saying, yes, it does, right? They can expand the NVRA. That's underneath the level of constitutional issues.
Thank you.
Thank you. Alan?
I'm Alan Shapiro. I'm a member of Baltimore Ethical Society and League of Women Voters. And I have a sort of revolutionary question. Is if the state of, say, California should decide that a Supreme Court ruling is both immoral and nonsense, and says, we're not going to pay any attention to it. Since the court has no enforcement authority, what happens?
Well, you don't want to walk down that path, right? There's a long, ugly history in this country of, the state's rights and nullification. Before that, secession, right? We don't countenance under constitutional law that states can ignore, right? The U.S. Constitution, it says, is supreme over all state law, all state constitutions, and all state executive actions. They have to obey what the U.S. Supreme Court says. They'd have no.
So what happens?
I'll walk down that path a little bit. First, I'll walk down it in a way that everybody agrees. Supreme Court says the death penalty is constitutional. California believes the death penalty is immoral. California need not execute anyone because some Supreme Court decisions are of the form. You can do this. And just as when your parents said you can stay up to 11, you could go to sleep at 10. Now, we'll talk now. Secession, disobedience has a very bad name because we associate it with slavery. When we think the Fugitive Slave Act, it doesn't seem so bad. And one of the questions really is, at what point do states, and they will need national support, but now imagine they make a ruling that both President Biden and the state of California think requires California to do horrible things. Well, we discovered in 1830, when the Supreme Court made a ruling that Andrew Jackson and the state of Georgia thought would require doing horrible things. It turns out we think Jackson was the one doing horrible things. But Jackson said, the Supreme Court has made their ruling, now let them enforce it. Again, in normal, and this is why I want to distinguish rebels, in normal times, everybody agrees Supreme Court is the highest authority, right or wrong. They make some decisions you don't think are so good, you live with them. When you think the court has been captured by a revolutionary group interested in enacting a constitution you do not recognize, the world is very different. Witness the struggles going on in Israel today.
I'll just add a little bit to this. I think I part ways just a little bit in terms, not just a little bit, right? I mean, I think for the future, you want the Supreme Court's legitimacy and power to be there, right? I think we all want these grave questions to be decided favorably in our time. We want to see a final resolution of these things on favorable terms, protecting, democracy and our constitutional rights. But a lot of what I do and a lot of civil rights advocates do is hold the line in these times and protect our constitutional rights as much as we can without trying to, I think, take any radical action that might spark violence or civil conflict, right? I mean, there's a great book, How Democracies Die. I think everyone should read this book. One of the key components or things they advocate for is institutional forbearance. There might be things that Congress, a Democratic-controlled Congress, working together with a Democratic president might enact, might even clearly survive constitutional scrutiny, and there'd be no way for the U.S. Supreme Court to do anything about it. Should they do it? if they can, should Mitch McConnell have held vacant a seat on the U.S. Supreme Court just because he could? There are things that people can get away with in politics that they shouldn't, even if they can. And I think much of what we do right now in this period of time is hold the line, I think, for the future, right? I mean, because these issues are going to keep being debated and fought over, but we can't. I don't buy necessarily into the notion that I think there's an attempt to engage in a legal revolution right now, but buying into that and saying that all the rules of the game have been thrown out the window, anyone can do whatever they want, whether they're a Democrat or a Republican, and should, just to gain a competitive advantage, I think is playing with fire, in my view.
Tina?
Hi, and thank you so much for your discussions. In Sheldon Whitehouse's book, The Scheme, he talks about a lot of interesting things, and one of them is he quotes former Justice Lewis Powell saying that the Constitution is whatever 5 justices say it is if there's no respect for precedent. And I'm just wondering, Professor Graber, if that's what you're saying, where we are now.
Constitution is not simply what 5 justices say. It's what the Congress says. It's what the president says. And that's always been the case. It's not where we are now. It's always when now, 50 years ago, there were different people in office. There were different kinds of coalitions. There were different politics. But I always warn you, there's in some sense, our differences are not as great as they seem. There's a point at which you're not going to unilaterally disarm. And there's a point at which I'm saying, no, keep the rules of the game going. But we do need to understand the situation. We need to understand that revolutionary movements, good and bad, don't fully play by the constitutional rules. Sometimes it requires adjustments to deal with them. And so I think we got the 14th Amendment and to some extent the 13th Amendment because Republicans refused to seat members of the Confederate States for a number of years. That was unprecedented. It was very creative constitutional thinking, and if you're a Republican, you believed in it. But we do need to understand that the role of the court changes over time. The court had a role in the 20th century. It doesn't have that role now. And while politics is polarized, it is unlikely to have that role. So all we can choose is figure out what's the best role the court can play in our politics, not what is the best role the court can play in the politics of 1980. And that's my little.
I do want to commend, there's a blurb in the back about the book, Sheldon Whitehouse's book, but the explanation of the dark money network and how it works is really spine-tingling. And I think what Professor Graber has been saying and what the kind of work Leslie and John are doing is saying to us as citizens, we have to do something too, or things are going to continue to get worse. So, we have to mobilize for democracy. And I think the book is a very good place to start.
One word maybe just to contribute to the last question that was posed, there's just one word of moderation or caution, right? I don't think we were having this conversation prior to what Mitch McConnell did in holding that seat vacant at the end of Obama's second term, right? I don't think we were talking of the Supreme Court in in such terms as if it had gone full fascism prior to the last 6 years of decisions. And I don't think before the balance shifted to 6-3. Things change and have changed in a more authoritarian direction, but they change fast. Would we be having a conversation of upending the rules of how the Supreme Court decides its cases, of how many people sit on the court, if it changed back within the year? If 2 Democratic justices replaced 2 conservative justices and the balance were 5-4 in favor of progressive civil rights rulings? I don't think we would, right? I mean, just reforms, we have to be careful with the reforms we call for. 10 years ago more than 10 years ago now, when I started in the voting rights and election law space, independent redistricting commissions were all the rage. Now that folks have seen the outcome of Democratic legislatures around the country unilaterally disarming and giving up power that they had to redistrict, I can't find many progressive voices in the community I work in who support IRCs anymore because they see what the consequences are, right? Grassroots groups, by and large, when you join these calls, I think there's a bill pending somewhere, I forget which state, for an IRC. You get on a call, not a lot of support for IRCs anymore. Reforms look differently as things develop, right? I mean, and I think we're all reacting to the moment, this long moment where things seem very bad, and there have been a number of extremely consequential rulings trending towards authoritarianism. But things can change fast. So I think whatever proposal for Supreme Court reform or for the substance of voting rights law, we just need to be careful, or about just even how the Supreme Court decides its cases. We should be careful about what we wish for.
Agree with John, because for 160 years, good progressives knew progressive policy is made in the legislature, not in courts who are inherently conservative. Okay, we had a good 20 years. We shouldn't think, because we had a good 20 years, if you're a progressive, courts are the place to make politics. We shouldn't change our progressive notions simply for that transient moment in time we call the Warren Court. Exactly right.
We agree.
Sounds like a good place maybe to say thank you.
Thanks very much.
And thanks to all of you, and thanks to the university.
And I'm actually not the judicial